Right, so Mr. Turner.
My lady, yes, the judgment. If
Yeah.
I could invite the court to turn to it, please. The discussion, the relevant section, begins at page 62 of the core bundle.
Thank you.
And as has been rightly identified, paragraphs 16 and 17 are effectively the meat of the judgment. And then at paragraphs 19 and 20, we have what's effectively a postscript in relation to Hewison. As my learned friend has pointed out, the case of Hewison to the learned judge, and the learned judge adds a postscript to deal with it.
So do you take any issue with paragraph 16 and 17, the meat?
I say they could have been expressed differently, but the ratio is clear that what the court is doing is affirming the correctness of the approach taken by the recorder below, and before that, His Honour Judge Leatham in the case of Agbalaya. And so whatever else follows, the ratio is their decisions were correct.
Right, so 19 and 20, Mr. Williams properly draws attention to the fact that the judgment hadn't dealt with Hewison, properly takes the point that the judgment was sent out for typographical errors, not further argument, but acts completely and perfectly properly in what he does.
Yes.
No complaint by what Mr.
No, of course
Williams
not.
did
We are
at
under a
all.
duty to point
Yes,
such matters out.
absolutely. So we then go to how the judge dealt with it.
Yes, and I can't support paragraphs 19 and 20. You will have gleaned as much from my skeleton argument. The comment that Hewison provides support, and the comment that Ajupong, the well-known county court case from the Lloyd's Law reports, also provides support for the issue which was under consideration. I cannot stand before this court and say that that is part of the respondent's case.
Right. Okay.
And that is because Hewison is an ex-Turpie Causa case. The focus in Hewison is on the individual's conduct. The focus in Hewison is on policy, effectively. There is an established loss that would otherwise be allowed, but then that supervening analysis is applied to, almost retrospectively, you could say, disallow it on public policy grounds. That's not this case. This case is about the quality of the article, not the actions of the individual. So I can't pray in aid paragraphs 19 and 20 of the judgment. But what I say is they aren't essential because the ratio descendi, the clear point in the judgment is as set out at the beginning of paragraph 16. I have in the end concluded that Judge Leatham in Agbalaya and following him the judge in the present case were correct. And their analyses were causation analyses. So the decision is based upon the logic in those cases below.
Sorry, their analysis were causation.
Yes.
Yes, sorry.
And the references, if we look in terms of the recorder, core bundle, page 158, and it's paragraphs 47 to 58.
Yeah.
You'll see these submissions at paragraph 48. Could not lawfully drive his car on the public highway, not a reasonable act of mitigation of loss. At 50, the recorder saying there, causation, this is second line, the causation defence is in my judgment a distinct defence which is capable of applying only to the credit hire element of the claim. That goes back to this all or nothing point as well, which was raised by my learned friend when he was saying that the courts below had misunderstood whether or not it was all or nothing. And then it's essentially, if I could leave the bench to read that, you'll see it's relatively short. And Judge Leatham's decision, the Aglabaya decision, that's at page 355 of the authorities bundle. In terms of the relevant section. .355 begins at paragraph 34, ends at paragraph 39. And that is where that fundamental distinction between a drivable car and a usable car, being a car that can lawfully be used on the highways, is first drawn. And that's at paragraph 36. So when the judge says, I agree with the recorder here, and before him Judge Leatham, he is adopting the causation analysis.
Does it matter that Judge Leatham also fell into the proclamation that Mr. Williams has drawn our attention to, that the illegality argument would defeat the entire credit hire claim? At the bottom of paragraph 36, that one sentence.
Yes, now that's the entire credit hire claim, not the entire claim.
Oh, I see.
Limited to that specific head of loss. And we get that from the very end of the judgment.
Yeah.
Where I've taken you to what was awarded, and the damages, general damages for pain, suffering, loss of immunity were allowed, pre-accident value was allowed, even though the judge did say at paragraph 60 that he would have found that there was ex turpi causa in relation to the credit hire claim if he hadn't already dismissed it on grounds of causation.
Right, okay.
So he was aware of that distinction. And I took you to the transcript of hearing, that was page 87, where, of the core bundle. Where it's clear that Mr. Justice Martin Spencer also understood that to be the position. So when he talks about it's a different entity altogether, he's not talking about ex turpi causa for the whole claim versus ex turpi causa for one head of loss. He's talking about ex turpi causa versus the causation argument, the no loss argument. And the distinction, to reiterate, is that ex turpi causa is the illegality is the reason for disallowing an otherwise valid head of loss or claim. But on the causation argument, that loss doesn't arise in the first place. Or to the extent that there is some loss, it's not loss that would justify hiring as a reasonable response as a step taken in mitigation of loss.
And since it makes no difference that it's credit hire, would not justify hiring an alternative vehicle?
No, because the quality of your own vehicle was such that you didn't lose use because it had already gone. So yes, it doesn't matter whether it's credit hire or spot hire or basic hire as terminology is used in the cases.
Yeah. It's just what we wouldn't want to give any hostage to fortune by treating the issue as entirely general and applicable both to credit and non-credit hire, if in fact there's a distinction between the two, but I don't think there is.
I can't think of one on the spot.
The only difference is that the credit hire charges are higher.
They are by some margin, by the way.
They're higher.
Yes. So the answer is I can't see a distinction because we are dealing with principles of loss of use, and it's the general damage which converts to special damage if you hire. Was there a loss of use? Was it a reasonable step taken in mitigation of loss to mitigate any particular loss that you may have sustained if you've sustained a loss in the first place? So that's the analysis, and it does appear to me to be an analysis of general application. Now, what Mr. Justice Martin Spencer says in the judgment is that this is the causation argument is a second, more targeted form of illegality. And that's at paragraph 17 on the third line onwards.
That's not your case, is it, Mr.
No.
Turner?
What I would say, and I would put it like this, and that would be consistent with the judge endorsing the decision in Appellant and the decision of the recorder below, and his statement of his understanding of the position during the hearing, is that we're actually dealing with three ways in which illegality may affect a claim. First, ex turpi causa non oritur actio. It affects the whole action. And that's a policy consideration. The second
Can affect the whole action.
can affect the whole action, yes. If
You said affects, which is to fall into the same error as is suggested that the judge below has made.
yes, what I'm going to go on to extirpicos non oritur damnum, where it's a subset effectively of the first the general extirpicausa principle.
Okay, so you're categorizing rather than saying this is. You're giving us very taxonomical alternatives as your three versions of how it can work.
What I'm
got it.
What I'm saying is, rather than say second form, he ought to have said a third way in which it could
now I understand what you're
influence the outcome.
So you can have ETC which affects the whole action.
Yes.
That's number one.
Number two, where extirpicausa affects just that particular head of loss, non oritur damnum from Huison. And then we have something entirely different, where illegality is part of effectively the factual matrix, the background, the evidence in the case, but it is not the reason on policy grounds that the claim is disallowed. And that is the claim for the specific head of loss affected. And it is relevant that this is a loss of use claim, and we're looking at the usefulness, the legal usefulness of an article. And that third category is what this case concerns. It's a completely different thing. It focuses on the article, not the individual. And what it says is that when considering whether or not a loss has been sustained, the court is entitled to bring into account any illegality that may affect the quality, the usefulness, the usability of the chattel.
Can I just see if I've noted this right? Because it may not be so clear after you've gone. Illegality is part of this is in your third category. Illegality is part of the factual background. It's not causing disallowance on grounds of policy, but on the grounds of factual absence of loss.
Yes, because the value of the article is, in terms of its usefulness, has already been so diminished by not being legally useful and usable that there is no loss.
And you look at the value of the article, not the individual.
Yes, the focus, extirpicausa, focus on what the individual did or didn't do.
Yep.
Was that worthy of moral condemnation? Effectively, should the law say, as policy, we shouldn't reward this? But here, what we say is, let's look at the car and to say that in terms of usability, legal usability, a car with an MOT has exactly the same value as a car without an MOT is wrong.
And that depends on whether, as I suggested this morning, the analysis starts with the claimant's need, or as you said in response, no, the analysis starts with the loss of the vehicle.
Yes. I say you get to need when looking at the reasonableness of the step taken in mitigation of a loss. But you have to have that loss in the first place. And if you don't have a car that is legally usable, it can't be equated in terms of loss with a car that was legally usable.
Speaking entirely for myself, and entirely provisionally, I can see why you say a car without an MOT is different from a car with an MOT. I have more difficulty with your next submission, which is that the car, losing a car without an MOT does not give rise to any loss. And I think that the difficulty for us may be that if I were to be right about that, if we held that I was right about that, we're then talking about betterment rather than no loss.
Or failure
Betterment
to,
is not an issue.
or failure to mitigate, because it hired at a point when it was not reasonable to do so.
So
And
you
that's-
haven't mitigated your general damages,
Yes,
which
the
have been converted into special damages.
You have, but you've overdone it.
You've overdone
Yeah.
it.
So
Yeah.
it's betterment.
Or failure to mitigate. Or losses not caused.
You haven't failed to mitigate. You have mitigated. You've absolutely mitigated your loss. You've just gone over the top and done more.
Yes, so on that basis, the court can say that in terms of mitigation, the higher costs weren't caused by your loss of use, they were caused by the step that you chose to take.
They were caused, but it may not have been a reasonable response, which is different, because that affects the level of recovery.
I accept the betterment analysis is one analysis that could be applied, but that doesn't mean an analysis which says, well, damages are reduced for a failure to mitigate because it was an unreasonable step taken in mitigation. That would be a valid analysis. Valid analysis to say part of these losses that you incurred in signing this hire agreement, they weren't caused by the accident because they're far in excess of the loss that you sustained. The cause was your decision to go out and hire.
Forgive me for keeping going. Is it the beginning of Patel, which has Lord Toulson setting out very conveniently 3 responses to loss? No recover. You don't recover for avoidable loss. I mean, it's absolute hornbook law, but I know I've seen it in the last 24 hours. Okay.
I
if you
couldn't say
haven't
off the top of my head, my lord. It's
No, don't worry. Don't worry. I'll find it.
But Mr. Turner, you already alluded to this in the last minute or so. The failure to mitigate must encompass the reasonableness of the mitigation, mustn't it?
yes.
And so another way of looking at it, and you have alluded to it, is that in hiring a car with MOT, when you didn't have a car with MOT, that could be interpreted as an unreasonable act.
Yes.
And that would build in to the failure to mitigate and the reasonableness of that mitigation.
Yes. And so that, I submit, is a perfectly proper analysis. And it in fact, it was part of the submissions that were made. If we look at page 60, paragraph 14.
60.
60 in the core bundle.
What is paragraph 14? Yep,
Paragraph 14, the last
got it. Yeah.
4 lines. And my lady, if you go to page 159, the Recorder's judgment. You'll see at paragraph 48, Mr. Cheatham's submissions in relation to hiring not being a reasonable act of mitigation. And we see that accepted by the Recorder at paragraph 50. And then at paragraph 51, makes the point that even more fundamentally, there's no loss in the first place.
So the Recorder certainly found that He wasn't even getting to mitigation. This was causation, as you say.
Yes, at 51,
Even more fundamentally, we don't get there, in other words.
we don't get there, but if we did, it wouldn't be reasonable
Yeah.
to hire anyway.
We need to change this label. This is not a causation defence. It's no loss. It's an assertion that there's no loss. Or no recoverable loss.
No recoverable loss because the loss has already been sustained.
Yeah, well, that's got nothing to do with causation. In my language. Unless I'm wrong.
But you're saying it's not a loss.
I'm saying it's not a loss. So the accident,
You made it absolutely clear. You're just saying there is no loss.
as is the
There is no
recorder.
loss. You don't get to the question of causation. You just say there is no loss. It's not a question of loss having been, on your analysis, it's not a question of loss having been caused, but you're just simply saying there's no loss.
Yes, I suppose fundamentally we are, because the loss has already been sustained by the fact that the car was not legally usable on the road.
No
So
loss to sustain. It's not the loss had been sustained. It's that there was no loss to be sustained. It's different, I think.
Well, the loss to be sustained was one that you say could not be compensated, because the loss that was sustained was the right to drive illegally.
yes, the right to use the vehicle on the
Sorry,
road,
yes.
and that had already been lost.
Yes. So, but that right to continue to do so, which Mr. Williams says was there, subject to criminal prosecution and penal code, you say, well, that was the only loss, and you can't compensate for that.
Yes, I say you.
Not ahead of loss, in other words, in this
no,
case.
it's not ahead of loss, but
That's my lord's point.
But even if it were, it would only take you to the mitigation point where you're saying, I want compensation because I've lost the opportunity to drive illegally, and here are some charges I incurred because I wanted to keep driving illegally. Well, the court would take a view on a mitigation argument based upon.
And the recorder
those
didn't get
facts.
there. The recorder didn't get to mitigation effectively. It just said, if I did, this is what I'd find. And of course, in the second appeal, we look at the qualities of the first judgment effectively.
Yes, well, my lady, he did get there because at 50, he effectively analysed it in a mitigation context following the submission at page 48.
Yeah, I'm not undermining your argument. I'm saying at paragraph 51, he's saying in order for the issue of mitigation to arise, it's necessary for the claimant to have a loss of use claim in the first place. And he's saying he didn't. That's a point. The recorder's saying this isn't a loss of, a mitigation. There's no loss.
I should take you to 56
Yeah, okay.
and 58 over the page because he deals with mitigation there as well.
So his finding was the credit hire claim fails because he has no loss of use claim. He didn't get to the mitigation. That's the point, isn't it?
Yes, the way he put it is the end of paragraph 58. So you think it's encapsulated there.
Yeah.
So mitigation was addressed, but in the context of no loss.
Yes.
As my lordship puts it. I'm essentially finished, but just to draw a few threads together. The appellant's case essentially is that having no MOT is irrelevant. The loss of the ability to use on a public road the car with an MOT is the same in terms of compensation as the loss of the ability to use a car without an MOT or with an MOT. And we say that that's just not acceptable, whether it takes you to general damages ultimately, because you say, well, if there was some loss, it was unreasonable to mitigate, and therefore the court has to do something of a jury exercise. But at the end of the day, the value of the chattel had been so diminished by the fact that you couldn't use it on the road that there was no loss. So nothing caused by the accident in terms of loss of use.
But loss of chattel, which was compensated for, and you take no issue with?
No issue with the capital cost, if I can put it that way, in terms of diminution in value. This is about usability, legal usability, and the focus must be on the article and not on what the individual may or may not have done. At the next stage, the court focuses on what the individual may or may not have done, and that is a question for a trial judge, it's a question of fact, unreasonableness. So, not ex turpi causa, but a different entity altogether, and a justifiable argument, and an argument which Mr. Justice Martin Spencer was right to confirm as correct, affirming the logic of the recorder, and before him, His Honour Judge Leatham in Malaya.
You just say you could have done it better.
It could have been worded differently, my lady. I've identified my 3 categories.
All right.
And I trust you have note of that.
Can I just ask your help on one other thing? And I'm dredging the recesses of a mind that hasn't had to be dredged here for a while. In tort, there's a series of cases. There was a famous fire case called Harbertsplasticine, and there was a second Harbertsplasticine, where I think the facts were that they had to replace a piece of equipment, and the piece of equipment they were replacing was a rubbish old piece of equipment, and they could only replace it with a new one. And it was held, one of the Harberts cases is a decision of Lord Denning, and I'm not sure whether this is Lord Denning or someone else. And it was held that the claimant was entitled to recover the cost of the new
Factory
without reduction. Because
yes, Harbertsplasticine, sorry to interrupt, my lord, I think
Harbertsplasticine
was the factory. It was a Victorian factory.
That's right.
Couldn't be rebuilt to its footprint because of planning regulations. And so the question was, are they entitled to recover the cost
I may be
of the
going
better
on,
factory?
but I am confident that there is a case in that same area. If it isn't Harbertsplasticine, we should be able to find it, where I think it was because of a fire, a piece of kit needed to be replaced, very expensive piece of kit. The one that was damaged was past its sell-by date, was old and decrepit, maybe. And the one that replaced it was brand spanking new, and they recovered the full cost of the brand spanking new one. And the reason why they did was because there was a loss which couldn't be precisely remedied. And the reason why this is bugging me is if we were to find that there was a loss, albeit not the loss of a car which you were entitled to drive with an MOT, you're presenting us with an absolutist response, which is because you can't replace it with a car which hasn't got an MOT, you get nothing. Or possibly, I think it's implicit in your argument, but we would need to think about it anyway, you just get general damages. First thing, you're clearly familiar with the cases that I'm trying to dredge up.
It might be Spartan steels and alloys with the turbines, where they have to have better turbines.
Could be Spartan steel. Yeah. Although I thought Spartan steel was about melting
the aluminium with the power cut.
Aluminium with power cut.
Yes.
Is that another Spartan steel?
No, that's the one, but they had to get new and better turbines, I think.
Okay.
Was the
No, that's British Westinghouse.
All right. Can
British Westinghouse.
The new and better turbines is British Westinghouse.
and
The new and better turbines, British Westinghouse. Thank you.
my ladies are being very patient. It may be that I'm just on a complete wild goose chase, but I'm not absolutely certain I am. I will have a look afterwards, and if I'm chasing geese, I'll try and stop. But if either of you think there might be anything in this, could you at least send the references?
Yes.
Yes, we'll have a look at that.
And
Lord,
when you do, is it pertinent to note that it's not the replacement of the car that's at issue, because that was quantified. It's the loss of use. So perhaps if those cases incorporate jurisprudence on the fact, I think, again, dredging my memory, that particularly in one of the Harbour's plasticine run of cases, the improvement or the betterment was said to be rightly allowed on the basis that the factory owner would not have chosen to have replaced his plant and equipment, no matter how outdated, because it was working all right
Yes. Now,
for now.
of
So,
course, well, we'll need to look at it in more detail. But,
yes,
but the immediate response to that would be yes, but they weren't operating it illegally.
illegally, yes, we can see that. But if you'll humour my lord and myself.
Michelle, and in terms of is the respondent presenting the court with an all or nothing? On the judgment, it was an all or nothing, no loss. But if you go to the next stage, mitigation, and the court finds you can't equate a car without an MOT with one with an MOT, then, depending on the findings of fact by the trial judge, higher does or can become unreasonable, and that does indeed take you back to the jury assessment, jury award in relation to what would be a fair figure for general damages, and that's paragraph 20 of Beechwood.
Or
which
it
I
takes you
alluded
into
to
the
before.
discussion we've had before, which is a finding of fact that I am satisfied that this car would have been entered for MOT. That's when that discussion will take place.
Yes, and then that would truncate the period, depending upon the court's finding of when the car would probably have passed an MOT.
Yeah, I understand your argument. I'm not saying I accept it, I understand it. Thank you.
So unless there are any other points from the bench.
Yeah, thank you very much, Mr. Turner. Mr. Williams.
My lady, I've got a miscellany of points, so I apologise if it's slightly disconnected. My learned friend began his speech by positing the objection a layperson would take if it was suggested that someone could be compensated for a car that didn't have an MOT. But firstly, for completeness, any suggestion there is an affront to public conscience test in this area was specifically rejected in Hewison, and for your notice, paragraph 27. But secondly, and I acknowledge that it might be said to be on the threshold of a jury point, but I do say it's pretty telling that at the very outset of his submissions, my learned friend basically has a naked appeal to policy. And that is telling, firstly, because an appeal to policy is the very thing Mr. Justice Martin Spencer said wasn't relevant for his supposed second
I
variant.
think you've got better points than
Yes.
that. Speaking for myself.
Well, very good. But
if you play the ball rather than the man.
well, I hope I'm just trying to play the point that's being made. That I'm just saying that it is telling that there's a constant assertion that this isn't the illegality point. The very first point that is taken is an appeal to essentially a policy consideration, which has the hallmark stamped on it of an illegality point. But I'll say no more than that. I hope it's already very apparent to the court that I yield to no one in my respect from a learned friend, and I certainly wasn't trying to play to do a low tackle, as it were. My lady, and I think again, I don't wish to repeat the sin I've just been rebuked for. But again, I do say it's quite telling that even as my learned friend is very skillfully putting these points, he simply can't make them because they cannot be made without constant return to the issue of legality or illegality. When he's addressing what was called the causation argument, he twice said the claimant has to show the loss of a legally usable car. So again, the legality is being put at the centre of his submissions. And just a few moments ago, when my lord put to him, well, should we relabel this no loss? Mr. Turner's reply was no recoverable loss. But that begs the question, well, why isn't it a recoverable loss? And in my respectful submission, the only reason it's not a recoverable loss that has ever been identified is illegality. All the other findings of the recorder were that it was an unimpeachable or incontrovertible loss because he was using his car, he needed to, he reasonably hired a replacement for a reasonable period at a reasonable rate. The only thing which ousts all of those findings and has led to the hire claim being dismissed is the fact that the usage of the car pre-accident wasn't lawful. And so I do say that when you really drill down to it, this ultimately is a constant attempt to redress illegality as something else, and it's an attempt that should fail. My lady, Mr. Turner then said on a number of occasions that it's an offence to use the car on the road. That, of course, is common ground. I do reiterate, however, that here the Act simply penalises use, it doesn't forbid it. And we will in the note include the contrast that I mentioned between this part of the Act and the part in respect of insurance, which actually says thou shalt not use, if I can. And our point is in response to the fact that the Act does penalise use, is that we say that this is an instance, and I think it's a point that was posited by my lord, that is a point that is adequately dealt with in this context by the criminal law. And of course, one of the points that comes out of the Patel case is that's the whole part of the whole balancing exercise. The court may have a starting point that the criminal law and the civil law should be consistent, but it has to set against that it may be that the criminal law fully legislates what the consequences of an illegal act should be, and there is no policy reason to add to them by also imposing a civil sanction, and Lord Toulson identifies that at paragraph 108.
Numbers for balancing between criminal law and civil law.
Forgive me.
Have you got the paragraph numbers?
Yes, it's paragraph 108 of Patel, which is page 206 of the bundle.
Sorry, paragraph
108, my lady, which is sorry. Let me just get this right. Paragraph 108 at page 206.
Thank you.
Now, as to the proposition that a car without an MOT is in some ways worthless, in our respectful submission, that is also an overstatement. The car can still be used, as this case shows, and if the car would pass the MOT, what you might have at most is a tiny abatement to its capital value by the fact that whoever purchased it would need to get an MOT immediately, unless they wanted to expose themselves to the risk of a fine.
I think it's a criminal offence to sell a car without an MOT, isn't it?
I don't know the answer to that.
Can you look at that in the page that you're going to do about the...
I have to say, my instinct would be that would be quite surprising, because it might be that you're just selling a car from your backyard, in which case it doesn't need an MOT if it's just parked in your backyard. It would only need an MOT if it was then driven away rather than taken on a low loader, for example. But we'll look at that.
Yes, I'm not sure of what I was putting to you. It's just that I think that there would be some... It's the same as trying to sell a sofa without a fire.
Yes, I understand that parallel.
Kind of thing.
Yes. As I say, I'm not sure that's the same, because the obviously you may sell a car for parts, for example.
Yes.
Yes.
I understand.
But anyway, in any event, presupposing that the answer to your ladyship's point is not. My lady, you're correct. So if you'll just indulge me to assume that might not be correct, then I do say that selling a car without an MOT, you would see a small reduction to its capital value on the assumption the car actually would pass the MOT. because all you would need to do is get it MOT'd, which doesn't cost very much. And the reality is anybody buying a car that's more than 3 years old knows that between 1 and 364 days he or she is going to have to pay for an MOT anyway.
Mr. Williams, I think, aren't we going off track here? Because you have been compensated, or Mr. Ali was compensated for the value of the chattel.
Yes, he was, that's fair.
So what Mr. Turner was talking about was it wasn't valuable in terms of being usable. But he's not saying that yes. This was your argument, which you've already alluded to.
Indeed,
which
and
is
I appreciate
he could have taken the risk.
And I appreciate it doesn't get better by repetition. Yeah. But yes, I say it's falsified by the fact that he did use it, and was clearly had been using it for 4.5 months. So my learned friend also in this part of his argument said, well, you have to look at the value of the loss. Well, I don't dissent from that, but the value of the loss here was that he lost the use of a car which he was using on a daily basis and on which, on the Recorder's uncriticised findings, was essential for both his work and his family life and that of his cousin.
So you would accept that there is a difference between having a car which you're using with an MOT and having a car which you're using without an MOT?
I might have said there's a very small difference in that you are liberated from the risk of a fine, assuming you're not already going to get one for the previous 4.5 months.
So for you, if we're against you on everything else, you would say there is a difference.
Well,
so there is a loss.
If you're against me on anything else, I would say that yes, I would say the consequence of the difference is truly de minimis, in that we know he'd been using the car for 4.5 months. He hired for 36 days. So it is the fact that he offloaded for that 36-day period the risk of getting a fine, which he may very well have already incurred during the previous 4.5 months. But he was enfranchised from that risk. And if the analysis is a betterment analysis, then I would say, well, that would be a classic instance of involuntary betterments that the court simply doesn't make an adjustment for, like Harbert's plasticine. But if I'm wrong about that and there is an adjustment, then I say the financial value to be attributed to the slightly reduced risk of getting a £100 fixed penalty fine. Well, it can't be more than £100.
Except he could be prosecuted for every day that he uses it without an MOT.
Yes, I suspect in the real world, however, I mean that of course takes you nicely into sort of Zeno's paradox when it comes to speeding, where theoretically, because time is infinitely divisible, you commit the offence an infinite number of times. For every.
The criminal law doesn't recognise that. It's it's a continuous offence. Yes. Speeding.
Yes.
But using a car individually every day is not a continuing offence.
But I think I do say that this area, perhaps more than when we're in the realm of damages and reasonableness and matters of that, so it has to be tempered by practical connection to what goes on in the real world. And in the real world, you're not going to have a fine for every day or every hour or even every week. You're just going to get fined. One would expect. Can I then just briefly? So really, all I say that the most Mr. Ali derived from the so-called betterment is that he is for 36 days. He's no longer at risk of a fine appearing in the post from the DVLA. That is likely to be a £100 fixed penalty offence. Can I then, and again, it might be, my lady, that this is something you would like us to touch on in the note, because I would just like to say a few words about the potential impact on insurance. The first thing I would notice under the Road Traffic Act, the offence is committed if there is no policy in force. So the offence is not committed simply because if you've got a policy but you breach its terms such that the insurer might have a contractual defence. There has to be no policy in force. And moreover, the effect of the Act, and it may be that the court is aware of this already, is that in general, most contractual defences as between insurer and insured are statutorily invalidated from the perspective of the third party. So the fact that an insurer, for example, may be able to refuse a claim because there's a bald tyre does not enable them to, as between themselves and their insured, it does not enable them to reject the third party claim. They have to pay the third party, but they have a contractual right to recoup their outlay from their insured. But
that's the insurer consent. Are you referring to doing that as insurer consent
yes.
under the MIB scheme?
Well, no. Under as the Road Traffic Act, insurer, I think, is the jargon that is regularly used. And as your lordship, I know particularly from your lordship's former editorship of the leading work on motor insurance, you'll recall that there is quite a complex regime in section, I think it's about section 143 through 152 of the Road Traffic Act, where even if the insurer can refuse a claim vis-a-vis its insured, it has no right to refuse the third-party claim. It still has to pay it, but it can seek to recoup its outlay from the insured if the insured is good for the money. But what I am saying is it mustn't be assumed that simply because an insurance policy says you must have an MOT and therefore the insurer might thereby acquire a contractual defence to a claim by its insured, that it follows that the claimant is committing the no insurance offence, because that requires there to be no policy. Can I also say, Mr. Justice Martin Spencer actually makes the point, again, for your note, I don't invite you to turn it up unless you want to, paragraph 18, page 63. I mean, he actually says, I don't quite, with respect to him, I don't quite know what he said it because it seems a slightly gratuitous aside, but he nevertheless says it's difficult to see that an insurer could validly have a clause that simply says I don't have to pay out if you don't have an MOT certificate. I mean, what I would say is that because motor insurance is almost invariably a consumer insurance policy, the ability of an insurer to simply to refuse cover because a claimant doesn't have an MOT certificate, even if, as a matter of fact, his car would cruise through the MOT test because it's in pristine condition, that must be highly suspect. But as I say, it doesn't actually matter because the insurance offence doesn't turn on whether or not the insurer has a defence. It turns on whether or not there is a policy. Can I then just deal with the counterfactual of a bald tyre? I don't for a moment accept that would be a less serious offence. In fact, my research over the short adjournment suggests that for a bald tyre, you can be fined up to £2,500 per tyre plus 3 points per tyre. So if you've got 4 bald tyres, you'll get 12 points and you'll lose your licence. So it is, it's an endorsable offence. And I do say, again, without wishing to play the man, there's a pretty telling caginess in my learned friend's response to some of my lord's questions to him about this issue. In his skeleton, he suggests, well, maybe there wouldn't be an issue if you had one slightly bald tyre. And I would suggest that it's not a leap from there to see that those sorts of caveats are being made by my learned friend because he doesn't want to shut the insurers who metaphorically sit behind him out from taking points about construction and use and such like if this appeal is dismissed. And that may be, so what? Let justice be done though the heavens fall. But the proposition that this can be localised to what is, even by the standards of motoring offences, because it's not endorsable, is at the absolute bottom of offences, because most offences are endorsable, like the bald tyre offence. The idea that insurers wouldn't be turning around and saying, well, this is a fortiori, because having a bald tyre is an immediate threat to safety and it has a more serious criminal sanction and it is an endorsable offence.
But you're going again into the illegality issue, which Mr. Turner says, I'm not talking about the illegality, I'm talking about no loss of use.
Well, my lady, of course he says that. But ultimately, the whole point that there's no loss of use is founded on because you can't use the car lawfully. And if you can't use the car lawfully because you don't have an MOT, then equally you can't use it lawfully if the judge finds that, but for the accident, you'd have carried on driving around with your imperfect tyres, or your mascot that obscures your view, or your broken wing mirror, or whatever it might be.
It raises very. If we go down the line of trying to distinguish between the value, at least at theoretical level, of having a car which has got an MOT which you use and of having a car which has not an MOT which you use, it becomes fabulously complex when one starts applying that to things like bald tyres.
Indeed, and the proposition that it would not set hairs running would be a false one in my submission. One only has to look at all experience in this area, and in factual terms, as you will know, very often a defendant sends an assessor out to examine a car that's been damaged. Absolutely routine in the insurance industry. So the idea that assessors working for defendant insurance companies wouldn't be tasked, make sure you measure the tread on the tyres, make sure the wing mirrors, make sure it doesn't have a mascot hanging down that obscures the view. I mean, these aren't sort of unreal attempts to make the flesh creep. This is unquestionably the reality of what would happen, and that I surmise and submit is why the most of my learned friend is able to say in his skeleton, given the commercial interest that sit behind him, is, well, maybe if there was one slightly bald tyre, it wouldn't be problematic. I mean, he caveats things in that way for a reason. Lastly, betterment and involuntary betterment, the debate about Harbert. We'll look at that, but just in the meantime, can I just say to the court that there's an exposition by Lord Hope of the involuntary betterment cases in the Lagden case, which we do have in the bundle, and Harbert is one of the cases discussed, and that's at pages 67 to 68 of the appeal bundle, if that's of any assistance. What I should say is there is another case called the Baltic Surveyor, where I see my lord nodding, where I think Mr. Justice Coleman did hold that I think from recollection it was a floating boon of some sort that went out to a wharf, which only had an extremely short life left. When as a result of that, he did abate the claimant's entitlement to damages on the basis that they would be getting something with a life of 30 years rather than just 3 years. So I'm not sure there are completely hard and fast rules in this area, but the general. In general, the principle about involuntary betterment is if it's genuinely unavoidable by a claimant, then you don't give credit for it, and that's Harbert's plasticine, and it's discussed at those references I mentioned. My lady, I just wanted to confuse, I've probably been doing plenty of that, a Freudian slip. I just wanted to conclude with a reference to consistency, because as you will know, the modern approach to the illegality defence, in famous cases like Lord Hoffman's speech in the Grey and Thames Trains case about the claimant who, after suffering psychiatric symptoms after the Ladbroke Grove disaster, kills someone. So the way Lord Hoffman approaches that, through to Patel and Mirza, is to say the real key here is consistency, and I do, and in contemporary jargon, an expectation the law will take a joined-up approach to these issues. And I do say that in those circumstances, it is a paradox in my submission that betrays there is something wrong in the defendant's argument. That despite the importance of consistency, according to the defendant, a court can quite properly say, one, the fact this car could not be lawfully used without committing an offence gives rise to no legality defence. But the fact the car could not be used without the commission of an offence means you haven't suffered a loss at all, or gives, as the recorder had it, a complete defence on causation. That I would respectfully submit that seems to be a very long way from a consistent and coherent legal system, rather than the opposite. And it's a pointer that the submissions from this side of the court are the ones which the court should accept. My lady, those are my submissions in reply, unless I can assist.
Thank you very much indeed. Not on the appeal substance, but I think you've got an issue about costs, haven't you, if you succeed?
Yes, I'm not sure. I didn't know that you would know about that. I think the expectation was that the bench wouldn't know about that.
It's just that there was the cost below.
Oh, I think they were just stayed.
Yes. Were they stayed before you applied for
I think Lady Justice Whipple stayed the costs below.
Yes, that's what I'm thinking of. Did she expect any argument on that? Because
no, I think the both sides have been content that,
Right, okay.
so we can leave that if that's
Yes.
may I just, before you rise, and I'm sure Mr. Turner, just to in terms of how we can assist you with the note. So we've got section 165, and we've got Harbert's plasticine, and maybe we can give you like a reference from McGregor or the discussion in McGregor or something like that. I did suggest at the outset to my Lord's inquiry about the sort of basic rules about loss of use and hire claims, whether Lord Hobhouse's speech in Diamond would be of assistance, but then Mr. Turner reminded us that it's looked at in Langdon
It's
too.
already, yes.
So would that be of assistance to the court to have Lord
Speaking for
Hobhouse?
myself, I'm happy that you do the note on the Road Traffic Act provisions regarding seizure,
Yes,
and that takes you into the regulations for what it's worth.
yes,
You have given us the reference in Langdon that discusses Harbert's plasticine,
Yes.
so that may that
but
will do.
very
will
good.
do.
If, of course, if we can assist the court during the reservation of judgment, as you know, you only have to whistle, as it were.
Right.
My lady, I refer to the case of Giles and Thompson and Singh and Kubi, which established the principle that the claimant has the burden of demonstrating need. Does the court wish to see extracts from those? They're not in the authorities bundle.
If it helps, I don't dispute.
I know where to find Giles, and would be helped by a reference for Singh, which I don't know.
Well, we'll get that through.
I think
as well.
if you can send both of them through, that would be easier.
And my lady, there
Right.
was also the question of, is it a criminal offence to sell a car without an MOT? Do you wish us to explore that?
It's only in response to something that Mr. Williams said. Because but I think Mr. Williams was talking about it in terms of the value of the chattel not being reduced in the damages that were paid for the damage caused to the chattel, which you say, well, it's already been paid for. The repairs have already been paid for. But if Mr. Williams wants to refer to it in another respect, then we should see it, I think. Could you get those matters seen to, and if you send them through to my clerk, then I'll make sure that they're distributed to my lord, my lady and my lord. Could I say 4 p.m. tomorrow?
I think Mr. Turner.
I'm in trial tomorrow.
All right. How about 10 o'clock on Monday?
Yes.
You've got
Yes.
the weekend.
Yes, that would be very helpful. And I think we've had dealings with my Lord's clerk in the run up to the hearing, but not as far as where your ladyship. So
well, carry on with that, if my lord
Yes.
doesn't mind. So carry on with that means of convoy of
Very
the
good.
information. So I think that's all that we need from you. So we are obviously reserving our judgments. We will endeavour, after we've received the additional information, to get our draft judgments to you as soon as possible. You know, it's the opportunity to correct our English, not to continue with any arguments that may occur to you subsequently. And thereafter we will hand down in the usual way. We hope our judgments will be sufficiently clear to enable a judgment, forgive me, an order to be agreed, which will include an order as to costs if required.
Thank you, my lady.
Thank you both very much indeed, both for your written submissions and your oral submissions today, and also for taking some teasing in good part, both of you.
Rise available.